This video lecture is on international trade law. It may cover some additional topics. The focus here will be on international trade, World Trade Organization, and the general agreement of tariffs and trade. We'll talk about the general principles, and then we'll talk about some specific international or global business legislation. Then the last of the lectures will be on doing business globally through foreign direct investment. Let's first start off with the discussion of the World Trade Organization. You will probably tell from this lecture that I'm not a fan of the WTO or the agreements. I'm not sure that it's the best approach for global trade in this country, but you decide for yourself. The World Trade Organization is an intergovernmental organization responsible for overseeing international trade. It's an umbrella organization. It has responsibility for implementing, administering, and carrying out the WTO agreements that we'll talk about, acts as a forum for ongoing multinational, multilateral trade negotiations, which is gone on periodically ever since the 1940s. And it serves as a tribunal, meaning that there is a similar to an arbitration process for resolving disputes. Well, why was the WTO necessary, and why were the agreements related to trade necessary? Basically, it was the problems resulting from protectionism. There was a need for multilateral action in dealing with trade matters because excessive protectionism led to worldwide economic depression in the 1930s. One of the most infamous pieces of legislation in the U.S. is the Smoot-Hawley Tariff Act of 1930. It raised tariffs on about 1,000 items. This was the highest in the U.S. history, and some of those tariffs were raised as much as 100% of the item's cost. Well, when the U.S. raised its tariff, and clearly it was done because of the economic crisis with the crash of the stock market and the Great Depression, other countries around the world, our trading partners, did the same thing by raising their tariffs, hence a tariff war. Well, this led to the Bretton Woods Accord after World War II, and in 1946, 1947, we had 20-some-odd countries that agreed that it is better to trade than to fight. So, ever since 1946, 1947, we had these multilateral agreements on trade. It was small to start off with and has gotten much bigger over the years, but that was the general agreement on tariffs and trade, commonly called GATT. The WTO headquarters is in Geneva. It was created on January 1, 1995, to operate as this umbrella organization. Presently, there are 162 members. Now, a member can be a nation or it can be a territory. For example, before Hong Kong became part, by extension, to the Republic of China, it was a trade territory and a member of the WTO. Last two of the WTO members were two that you probably wouldn't think much as trading countries: Yemen and Seychelles. And I'm not even certain. I don't even know where Seychelles is. A new member must be approved by 2/3 of the member states. A member can withdraw from the WTO if it chooses, but if it chooses to withdraw from the WTO, it would throw itself outside of normal trade relations status and put it in full application of all tariffs, meaning generally your trade would suffer. All members of the World Trade Organization must comply with the agreements, all of the agreements, except for some of the plurilateral agreements. The budget is large, 634 staff members, and a total 2014 budget of over $200 million. The WTO maintains, through the members, a number of agreements, and the WTO is responsible for making sure they're all complied with. There are 14 agreements on trade in goods, the GATT being the principal one, and there are other agreements that make GATT go, so to speak. The second most important agreement is the General Agreement on Trade and Services. This is one that was new as of January 1, 1995. And the third major agreement was the Agreement on Trade-Related Aspects of Intellectual Property Rights. These last two, Trade and Services and TRIPS, as they're called, GATS and TRIPS. These are two that the United States was insistent on getting agreement to because the U.S. is stronger in services and intellectual property than probably any other country on the planet. Other significant agreements is the Dispute Resolution Agreement, understanding the rules and procedures governing the settlement of disputes. This sets up a dispute settlement panel and appellate bodies, kind of like an international court, if you will. Trade policy review mechanism. There are two plurilateral trade agreements, and these plurilateral trade agreements are agreements that only a relative few number of countries need to concern itself with. For example, aviation, simply because of sophistication of the economy and the size of the economy lend themselves to participation in these industries. Most countries do not have the size or the wealth or the industrialization to participate. Well, let's look very generally. We won't talk about all of these, but those agreements on trade in goods. As we said, the most significant of all of them is GATT, General Agreement on Tariffs and Trade, 1994. Now, as I said, we've been going through these rounds of negotiations, the first being the Bretton Woods Accord in 1947, and periodically we go through others. It was the Uruguay round that led to GATT 1994, and that's the one we're still working under. We have other agreements on agriculture, sanitary and phytosanitary measures, for example, disposal of waste. Think of a barge out at sea, a garbage barge out at sea. What can it do with the garbage? Where can it go, etc.? Textiles and clothing, obviously, it's not as important to the U.S. as it was, but it is important to a lot of other countries. Agreement on trade-related investment measures, the U.S., EU would be very important in that. And then we have 4 important ones. In essence, these type of agreements make GATT go. The anti-dumping agreement, the agreement on implementation of Article 6, this is anti-dumping. This deals with pricing of exports. We'll mention that in just a little bit. Then customs valuation, the agreement on implementation of Article 7. How do you value goods that are exported and to which customs duties or tariffs would be applied? The agreement on pre-shipment inspection. This has become more important as an efficiency and a safety and security measure post September 11th, 2001. And then the agreement on the rules of origin. Where did the goods come from? All right, what's the origin of the good, the country of origin? This is important because of application of tariffs, especially since we have customs unions and free trade zones. There would be manipulation if we didn't have these rules of where the goods come from. The import licensing procedures, and then another major one, the agreement on subsidies and countervailing measures. We'll talk about subsidies later. We don't need to talk about the plurilateral agreements. I've told you what they are and why. Very briefly on dispute resolution. All right, so suppose we've got WTO members that are in a disagreement over the application of GATT or one of these other agreements. And they have a simple international trade dispute. How is it going to be resolved? Well, the mechanism generally is that the WTO provides this tribunal system for resolving the disputes. Before you get to a tribunal, there is generally an attempt to resolve it through negotiations, through the use of good offices. That basically is a country that will try to resolve it. Conciliation and mediation, like we've talked about before. So consultation, negotiation, the good offices, and conciliation and mediation. From there, if you don't have resolution, then you go into the formal dispute resolution process. A dispute settlement body will convene. And this is called the dispute settlement panel. Generally, it's 3 countries hearing the dispute, a lot like arbitration, and they are decision makers. They have powers to make decisions. And what you will have is you've got the parties to the dispute and the general counsel, which is basically the whole membership, will select representatives from 3 countries to hear the dispute. Now, one of those 3 countries has to be a small, undeveloped, non-industrialized country if one of the disputants is also of a similar nature. If the dispute is not resolved, or if the one party to dispute does not like the dispute settlement panel's resolution, then an appellate body can be established by the WTO's General Counsel, and this will act as an appeal of the dispute. Let's look at GATT 1994. It's very similar to GATT 1947, the original. The main thing I want to talk about with GATT, and GATT deals with goods, right? With goods, not services, not intellectual property. There's a separate agreement, GATTs and TRIPS for those. But the way GATT is worked out is there are 9 guiding principles called general principles that make GATT effective. And we're going to talk about these 9 principles. That's going to be our major focus. Just to quickly go through what these are, and then we'll spend time on each one of them. The direct effect principle, non-discrimination principle, which is a major one of them, and the non-discrimination principle has 2 focuses. One is most favored nation or normal trade relations status, and the other is the national treatment rule. Then there's the protection through tariffs principle, the transparency principle, regional integration principle, which has become more and more important, escape clause principle, and the commodity arrangement principle. We'll talk about each one of them. First, the direct effect of GATT principle. Some provisions of GATT are directly effective, meaning that private persons of a member state may rely on them and enforce GATT 1994 provisions against their own or some other member state. Sometimes a company's own member state does not take up for it, so to speak, does not bring an action to enforce the principles. This was the case in the Finance Ministry versus Manifattura Lane Marhotto from an Italian. This is an Italian dispute in which Italian wool producers were not protected by the Italian government in order to stop importation of certain goods, and so they sued on their own behalf. They sued the Italian government and were successful. Second, and this is the most significant, is the non-discrimination principle. I think this is the one that makes GATT go. Now, what we say about these 9 general principles of GATT, these also apply in large part to trade and services, GATTs, and TRIPS, especially with regard to non-discrimination principle. It's the most fundamental principle of GATT, that international trade should be conducted without discrimination. Hence, here's where we have general consensus, so to speak, that all nations should be treated equally in trading of goods. There's a good side to this and the bad side to this as well. It's this particular principle, this non-discrimination principle, is a principle of non-discrimination, and its foundation rests on 2 sub-principles, so to speak: the most favored nation rule and the national treatment rule, both of them being non-discrimination principles. First, the most favored nation rule. It's also referred to as normal trade relations. And in fact, if you look at the harmonized tariff system, you will see a reference to NTR, normal trade relations, rather than most favored nation. This particular provision, most favored nation provision, says that any trade advantage or privilege granted by one GATT member to the goods of another member should be granted to all. Now, this is extremely important. Any trade advantage or privilege granted by one GATT member to the goods of another member should be granted to all. That basically means is once you negotiate a tariff, that tariff is going to be applied to all members of the WTO, or none at all. Now, a little bit later, we're going to talk about a couple of exceptions. The generalized preferences system, and free trade agreements, and economic unions. But those are the exceptions. Any tariff, tax, or other restriction on imports should be applied equally to products without regard to orientation. So as much as we complain about China, for example, here in the U.S., if we negotiate a tariff of only 3%, China is going to get that 3% tariff, even if we would prefer to give that 3% tariff to the EU countries and then have a 10% tariff for the Chinese. Every member gets it. The favorable tariff treatment to one country must apply to all countries having MFN or NTR trade status. The effect of normal trade relations status is that it results in the overall purchase price of goods being reduced and the goods becoming more price competitive in the import state. There are certain exceptions. First, the use of measures, meaning additional tariffs, to combat dumping and illegal subsidies. More on those in just a minute. Second, the creation of customs unions, like the European Union. And secondly, the free trade areas, like NAFTA, the North American Free Trade Agreement, or CAFTA, the Central American Free Trade Agreement. And these free trade agreements, the Chinese have negotiated a number of them, especially with Asians, Southeast Asian, and the African countries. We tried during the Bush administration to negotiate the free trade of the Americas, which basically would have brought in all of the countries of the Western Hemisphere, North America and South America, into a free trade agreement. But we had some of the larger economies in South America that simply did not want to partner with the United States. We have special restrictions that protect public health, safety, welfare, and national security. And there are special exceptions to aid developing countries. This is the generalized preference system that we'll talk about. This generalized preference or generalized system of preferences is one. The U.S. is one of those countries participating as an major industrialized country. So we're one of 11 countries worldwide, major countries that in the U.S. was established by the Trade Act of 1974, and this generalized system of preferences under the 74 Act promotes economic development by eliminating duties on up to 5,000 types of products when imported from one of 122 designated beneficiary countries or territories. Now, these are poor countries compared to major countries like Germany and France, Great Britain, the United States, Canada, etc. It's a one-way street, so to speak. We will buy their goods at lower tariffs, but we will not require reciprocity. We won't require reciprocity. Therefore, it gives poor countries the chance to trade with these 11 participating developed countries without requiring them to import from us at lower tariffs. The South-South preferences, there we're looking at Africa and South America, that allows them to grant tariff preferences to each other without having to grant them to developed states. All right, let's look at the national treatment rule, the second part of this non-discrimination principle. Also extremely important. And this principle says that once imported goods are within the territory of a member state, that state must treat those goods no less favorably than it treats its own domestic goods. Meaning you cannot discriminate. Now, we talked about discrimination under the Commerce Clause under the Constitution, how some states or localities prefer residents over non-residents. It's the same way in international trade. For example, the import state cannot tax imports higher than it taxes domestic goods after they enter the country. Now keep in mind, when a country is importing goods, customs duties can be applied on those goods when they come into the country. But, for example, we cannot place excise taxes on them after they come to rest in this country. Furthermore, the National Treatment Rule prohibits discrimination in customs procedures, government procurement policies, and product standards. Meaning you cannot use the government's red tape to make it more expensive and burdensome to import goods, such that exporters simply would not want to jump through those hoops because of the additional expense. GATT does permit, however, the states, meaning member states, to levy charges on the movement of goods, such as user fees, for a harbor, for example, or a port when the goods arrived. That is not an exception. To assure compliance with the National Treatment Rule, GATT requires member states to notify the WTO of any changes to their trade regulations. So what we have here is we have a push for transparency. Transparency of the states and the rules and the regulations on importation and the application of the customs duties go a long way to meeting the national treatment rule, and also reduces the burden on importation. Let me give you an example of a case involving the national treatment rule and through the use of taxation. This is a case out of Japan, in which Japan was the importer, meaning the exports were to Japan. This is the taxes on alcoholic beverages from 1998, before a World Trade Organization dispute settlement panel. And this is one in which Japan lost. Now, Japan has this alcoholic beverage called liquor, if you will, called sochu. Not sake, but sochu. And it's made, it is distilled. Japan was applying a tax on distilled liquor, for example, vodka. And that tax was not also applied to sochu. And so it made liquor like imported liquor, like Smirnoff vodka, for example, more expensive in Japan than sochu. Now, when you're talking about substitutability, as we talked about in antitrust under the Sherman Act, Section 2, the rule of the principle of substitutability and what price has to do with it. So if you made that principle of substitutability, suppose if you want to drink to buy vodka, because the price would be higher as a result of the taxes, you would switch to a substitutable product, and this would be sochu. Anyway, it was more expensive to sell a drink like an alcoholic liquor like vodka than it would be sochu, giving a price advantage and a preference to sochu. So there was a claim by the exporters, the countries exporting, that this was a preference for a Japanese product, and it violated the national treatment rule. The dispute settlement panel heard evidence that this was substantially the same product. And so this national treatment rule required there to be a consideration of like-kind product. Now, this notion of like-kind is a notion that tax accountants are familiar with for like-kind exchanges under Section 1031 of the United States Internal Revenue Code. They looked at the dispute settlement panel, heard the evidence that sochu is made in a similar process through distillation, like comparable drinks like vodka. And therefore, since it's made the same way, the alcoholic content was similar, then the taxation should be similar. And so the dispute settlement panel, holding against Japan, held that these were like-kind products that should be taxed the same, and so Japan had violated the national treatment rule under GATT. Some exceptions to the national treatment rule: subsidies to domestic producers, screening of domestically produced film. Now, you would think that, yes, this would be something that the French would want, and true enough. The procurement by the government agencies for government use only. It's the government's money, therefore the government can choose to buy its by goods produced by its own citizens, in essence, by American. And another thing, when I travel for the Fulbright Commission, when I did a Fulbright scholarship to Bulgaria in 2010, under the Fly American Act, I had to fly to Bulgaria, to and from Bulgaria, on a U.S. airline, and had to get permission to fly Air France once. All right, the next principle is the protection through tariffs principle. This is principle number 4, actually. And the protection through tariffs principle states that each member state may protect its domestic industries only through the use of tariffs. Tariffs meaning customs duties. Through taxation. You can't protect it through special legislation or through rules or through by treating countries different. You cannot use quotas or other quantitative restrictions on imports and exports. The tariffs must be collected at the point of importation. Now, there are very limited situations where quotas can be used, and that's generally by agreements. For example, as in textiles. For some member states, it's very important to protect textiles, for the country to be able to provide clothing for its people. Certain exceptions to the protection through tariffs principle. You can have temporary export restrictions to relieve critical shortages of foodstuffs and other essential products. I mean, this is out of necessity. This is not out of protection, but out of necessity. Second, restrictions related to the application of standards or regulations for classifying, grading, or marking commodities. You can have consistency there, as long as these rules are reasonable and not meant to be burdensome or protective. Third, you can have restrictions on the importation of agricultural and fishery products to stabilize national markets, to safeguard balance of payments. If the country, member state, is having too much of its currency leave the country because they are suffering trade deficits, you might have to cut off some of the foreign trade in order to stabilize your currency. And sometimes, out of necessity, economic necessity, a developing state may find it necessary to further to restrict imports in order to build up its economic, to build up its own economy. The next major principle is the transparency principle. The transparency principle means that the government will disclose to the public and other governments the rules, regulations, practices they follow in domestic trade systems. Transparency. Here the use of the internet has created the ability to have transparency as the world has never seen. In fact, we're probably, all in all, with the internet, we are more transparent. Countries are, on the whole, are more transparent than they've ever been. For example, if France is the only EU country that it's somewhat difficult to find their laws in English. But for example, the newer EU countries, for example, Bulgaria, you can find their laws published in English, in native Bulgarian, but also in English as well, and the same with Germany and so forth. The French are more protective of their own culture and their own language. But this adds to transparency. Under the transparency principle, states should simplify their trade regulations. And just like with the World Intellectual Property Organization, the WTO has done this as well. One major way in which we've got greater transparency over the years, and this has been it's been worked on since 1950, is harmonization of domestic trade in the systems and classifications through a harmonized tariff system. This is brought about by the Convention on Nomenclature for the Classifications of Goods and Customs Tariffs in 1950. It created a tariff system, a tariff schedule, if you will, with 900 tariff headings. You remember from high school how we used to classify plants and animals, the kingdom, class, phylum, subphylum, and all that. The nomenclature. It's the same way with goods for application of tariffs. And the fact is, what you need to do is do a Google search of the harmonized tariff system, and work your way through it. Find a commodity, find a product that you want to think about, an item of clothing. If you go to clothing, well, you can look within clothing. What's the nature of the clothing? Is it going to be skirts, blouses, pants, suits, coats, whatever? And then you would go to the classifications, the subclassifications for what are they made out of, or how are they made. And in that, under the harmonized tariff system for the United States, you're going to see the tariff schedule, how the tariff is applied, and you will find it for normal trade relation status, NTF, and you will find it for the generalized system of preferences, and you'll find it for the free trade agreement, for example, NAFTA or CAFTA, and then you will find for a much higher tariff for non-normal trade related. Basically the non-WTO members, and you will see how it was almost impractical to buy or to import such goods. The next major principle of GATT is the regional integration principle. This is the one where countries are negotiating more. And this is to promote international trade through regional economic integration. The WTO encourages states to participate in free trade areas, free trade zones, and customs unions. A free trade area is a group of states that have reduced or eliminated tariffs between themselves, but that maintain their own individualized tariffs as to other states. In essence, what we have, and we can use NAFTA as an example. All right? We have basically the three countries, the United States, Mexico, and Canada, have negotiated concessions with each other. And we've done this through goods, and we've also done it with tariffs, with services as well, in which we basically say we can agree on, going through each one of these, through harmonized tariff system, through each one of these classes, and most of them, for example, we will agree that there will be no tariffs at all. No tariffs for goods. Those goods come in from Mexico into the U.S., or from Canada in the U.S., or the U.S. to Canada, U.S. to Mexico, or Canada to Mexico, Mexico, Canada. In some, you would agree that there is a small tariff. But all of these tariffs would generally be less than under GATT that you would charge countries like Vietnam or Russia or China or Japan. Now Mexico has worked out a free trade agreement with, I believe, with China. And China has worked out free trade agreements with a lot of countries. In essence, we are through free trade agreements. We are ratcheting down customs duties, tariffs, much, much, much more than under GATT itself. But you cannot negotiate a free trade agreement and then raise tariffs on everybody else. You cannot do that. The customs unions, the group of states that have reduced or eliminated tariffs between themselves, and also have established a common external tariff which all of the group's states will use. And here we have the European Union. Member states that want to negotiate free trade agreements have to notify the World Trade Organization of its participation. The next major agreement is one that really doesn't apply much to the United States, but it applies to certain countries that have certain commodities of a limited nature, like tea and coffee and oil and things of this nature. Maybe even cotton would be one as well, in which the United States would have an interest. In these commodity arrangements, the intergovernmental agreements regulating the production and supply of primary commodities, those acquired through extraction or harvest with minimal processing. And because you have a limited number of countries that have these commodities or are able to produce these commodities, GATT allows member states to participate in commodity agreements, provided they involve both exporting and importing countries. All right, for example, the oil producers, OPEC, they are allowed to negotiate agreements among themselves. Once established, the organization, for example, like an OPEC, operates separately from the WTO. The next major principle of GATT is the escape clause principle. If you're familiar with the Broadway play Damn Yankees, in which the devil has made a deal with the lead character who wants to make the Washington Senators a winning baseball club again, just to beat those damn New York Yankees. He's a real estate broker, and he negotiates an escape clause with the devil that allows him to get out, because he has to sell his soul in order to become somebody like Shoeless Joe Jackson, or as he's called, Shoeless Joe from Hannibal Moe, the star of the Washington Senators. He has to give up his soul because he sells it to the devil for his dream. And he negotiates an escape clause because he's a real estate agent. He's slippery. This is the same principle of escape for the member states. How can you get out of a bad situation? Well, under the escape clause principles, GATT allows an emergency action for a member state to temporarily avoid GATT obligations when there has been a surge in the number of imports coming from member states. But there's got to be a showing that the surge of imports seriously injure or threaten to injure one of the members' domestic industries. This is what was threatened in the 1970s by the U.S. because the Japanese were just eating the big three American automobile producers' lunch when they were able to sell their cars so much better in the U.S. than the big three were. So there was a negotiation, a voluntary, if you will. Remember, you cannot have quotas, but you can have voluntary agreements. And so the fear that the U.S. would cut off importation of automobile cars that were smaller, more fuel efficient, higher quality, cheaper than the American cars, because of this threat, Japan voluntarily reduced the exports of these automobiles to the U.S. Eventually what happened, the Japanese manufacturers started opening assembly plants in the United States, and they obviously made even more money. The exceptions principle. Sometimes the public policy dictates that GATT principles of liberalized trade must be reduced because of national concerns. GATT can't be arbitrary, or it can't be unjustified or disguised discrimination. It has to be necessary. It has to be real. Security exceptions. When security is tantamount, is above all other things, you can reduce imports. Then you have general exceptions. And under GATT, these general exceptions are broad. They may be based on moral grounds or economic grounds, or simply nationalistic grounds to some extent. For example, it's necessary to protect public morals, necessary to protect human, animal, or plant life or health. It may relate to importation of gold or silver, and you know how important gold or silver is to national economies. It may be necessary to comply with the laws not inconsistent with GATT. They may relate to products of prison labor. There's a case involving the U.S. and China. It was one in which the United States won because this is the China diesel case, in which the United States or China diesel had been exporting to the United States a diesel engine, and unbeknownst to the United States, China diesel had been used in prison labor. Once the United States found out that these imported goods were made from prison labor, this was repugnant to the United States morals and social policy, and therefore they stopped the importation of these diesel engines made with prison labor. A GATT dispute arose, and the U.S. won. And lastly, there may be necessary to protect national treasures of artistic, historic, and archaeological value. Might be necessary to protect exhaustible natural resources. Might be essential to acquiring goods in short supply. And it might be necessary for government stabilization. I don't want to, the next few issues, I don't want to talk about in great depth. I just need to introduce you to them. Customs valuation. The issue here is how are we going to value the goods for applying tariffs? How you value the goods determine how much tariff is involved in it. You can, it would take too much to explain the valuation methods, because it applies some cost accounting methods, whether it's transactional or deductive value, or computed value, or derived value. It's beyond the scope of this lecture. The second issue is dumping and the application of the anti-dumping code. The issue here is that one producer in a country sells its goods abroad cheaper than they sell their goods in their home country. Why do they do this? Well, if you are able to export your goods, that means that you are keeping your people, your citizens, employed. And it actually works more of a direct costing argument. So as long as you're covering your variable cost, you're okay. You should sell as long as you're covering your variable cost. So if the government is going to have to subsidize unemployed workers, then it is better for those workers to be employed and work, and simply manufacturers simply selling for those goods for less. Well, the effect is when those goods are imported at this lower cost, they're the dumped goods, it affects the market of goods within that industry. And it causes the local producers within the importing country to suffer losses. What the anti-dumping code does is allow the WTO member states to counter dumping through the application of anti-dumping duties. The anti-dumping duties are tariffs sufficiently high to cover this additional, this reduction in the sale price, if you will. In essence, it equals it out. It creates a fairness and equality. There's got to be, for the anti-dumping code to be applied, there's got to be a material injury or threat of material injury to a domestic producer. Now, the reality of it is when a country applies these anti-dumping duties, there is generally going to be retaliation. When I was in China in March of 2000, or 2002 rather, China had just become a new full member of the WTO. And China had been participating with some other countries, some other steel producers, and I think Great Britain may have been another one. But anyway, one of the significant perpetrators was China, People's Republic of China, and they were dumping steel on the United States, damaging the steel producers in the U.S. And President George W. Bush hit the nations dumping the steel on the U.S. with anti-dumping duties. Now, the retaliation by China, first of all, they said they weren't dumping. So their retaliation was to apply anti-dumping duties to some of American goods. It's like getting in a shouting match. Both the injured industry and the importing states can proceed against the dumper. The second big issue which can result in sanctions are illegal subsidies, and then the application of countervailing measures to defeat those illegal subsidies. Here's the situation, is that these measures, these countervailing measures, prohibit certain types of specific subsidies by governments to promote export trade to the detriment of another state. Historically, Japan was guilty of this. China has been guilty of this, and we have fear, in the future about China and automobile industry, for example. So, some countries, in order to expand their economies, basically target a particular industry. We want this industry to mature and become an exporting industry. And so we will target this industry for growth and development, and the government will pay money to assist in developing the industry and assist the country, the industry, into being an exporter. And when you're an exporter, you create the jobs, you create the wealth, because as you sell abroad, you get all of the benefits of local employment, and you get the profits coming back from the sales abroad. Now, you can say this for example, historically, what has the United States done with, say, regards to cotton? And then this is one in which the cotton farmers took it on the chin with suits in the WTO by the other cotton producers. So the government subsidy, which may be good, it may be bad, it may be legal, it may not be legal. The government subsidy can be direct or indirect transfer of funds. And that's obviously the easiest one to see. It can be through providing goods and services in lieu of payment of funds. There can be loan guarantees. This is the equivalent of payment of funds, or conferring any form of income or price support. Price support, for example, to the cotton farmers for the purpose of exportation, because we don't have a lot of use for the cotton in this country, because we don't have that much in textiles anymore, not like we used to 40, 50 years ago. So why do we need to subsidize cotton farmers? Well, what we've got here is we've got three types of subsidies, broadly speaking. We've got one problem area, one that may be a problem area, and one that's not a problem area. So we could call these, red, yellow, and green subsidies. The red subsidies are prohibited subsidies. They are presumed to be trade distorting. They depend upon export performance, or depends upon the use of domestic instead of imported products. This is the targeting. This is the fear. This is the fear, probably for the EU and the U.S. about China, as China develops its own automobile industry. And when it does this, it should be able to develop automobiles much cheaper. Now, China has opened up an assembly plant for its automobiles in Bulgaria, and this way it will be able to export as an EU producer. It'll be able to export their automobiles into other EU countries. Now the question is, what happens when those cars are able to be produced in China and exported to the U.S.? Then we'll look to see how much subsidizing the Chinese government has done. The second batch of subsidies are the maybes. They're actionable subsidies that may or not be actionable depending on their use. What's the intent? They're discouraged, but they're not prohibited. Consideration will be, will it injure a domestic injury of another state? Will it nullify or impair some benefit due another state under GATT? Or will it cause or threaten to cause serious prejudice to the interest of another state? If the answer to that is all three, then probably would be illegal. And then the green subsidies. I think I want to go back to this one, the yellow subsidies. You might recall that a few years ago, President Obama specifically addressed his goal of having the United States be the principal manufacturer and exporter of solar panels. And it was willing, with this goal, it was willing to give large subsidies to solar panel manufacturers in the United States. I guess Solyndra being one of those, although it failed. Now suppose President Obama's plan had come into fruition, and suppose that the United States, we had solar panel manufacturers in the U.S. exporting to countries around the world. Question would be, would the subsidies that would be paid to the solar manufacturers in the U.S., would these be illegal subsidies provided by the United States government, and could the importing countries that also produce solar panels, would they be able to sue as a result and apply, even before the suit, apply the countervailing measures, meaning enough customs duties to offset the subsidies? That's the way the countervailing measures work. Countervailing duties offset the benefit of the subsidies through higher tariffs. The green subsidies are not a problem generally. If they assist in research and development, if they aid to disadvantaged regions, if they help existing facilities adapt to new environmental requirements. If the argument was that any subsidies to U.S. under my hypothetical, or under the president's plan that didn't work out, would the subsidies to companies like Solyndra, would they have been green subsidies as R&D and to adapt to new environmental requirements for the United States? Note that under the situation that I just gave you about subsidizing green energy, so to speak, if the purpose there is to produce for the U.S., all right, and in essence to make us greener as a nation and to be less dependent on fossil fuels, then that would probably, the subsidies would not be illegal. Well, we talked about the country of origin, the rules of origin. I don't think we need to go any farther into that. Let's look at very briefly, and we're getting toward the end of this lecture, other important importing law. There are a lot of them. There's a lot of legislation over the decades. 380 or so, and more than that now, United States laws affecting importation of products. For example, a significant one is Currency and Foreign Transactions Reporting Act. This requires reporting of exporting or importing money instruments of $10,000 or more. Basically, this is to fight crime. It's principally for drugs. Now it can be for terrorism as well. So the exchange of cash or certificates of deposit or something of this nature, but mainly cash. Well, actually, this cash or coin, currency, certificates of deposit, forget that. That would be, once you hit that $10,000, you have to report this to the federal government. And it would be the same, for example, selling a new car for, a new car dealer selling a new Versa for $11,000 cash. They would have to report that to the Department of Treasury. The Tariff Act of 1930 authorizes the U.S. Customs Service to enforce laws relating to assessment and collection of duty and the exclusion of prohibited goods, for example, convict labor that we talked about before, and the regulation of vessels and customs brokers. The Trade Act of 1974 extends authority to anti-dumping and countervailing duties and the generalized system of preferences. We talked about each of those. The harmonized tariff system that I referred to earlier, this is one in which you really need to go to the internet to explore. You will see the essential nature of it. I want to give you an example that I got. I attended the International Bar Association meeting in Amsterdam in 2000, and I attended a session on taxation. And one of the speakers was a customs tax lawyer, and he spoke of how the proper classification of a commodity, of a product, and how you can a manufacturer can use that classification. There's insignificant differences in classification to their advantage by taking advantage of reduced customs. In his particular case, he had a client that manufactured tennis shoes, your typical tennis shoes. And the tennis shoes that they had manufactured were tennis shoes that had the rubber rim all the way around the edge of the shoe. And if you think of the old Converse, and it had the cap of the shoe where the toes were, that was rubber as well, and canvas for the rest of it. Well, then the tariff on that was very high because we obviously didn't really care to have those shoes in the United States, and so it had something like I'm ballparking it, a 30% tariff on it. The manufacturer of the shoes found that they could change the style of that shoe and the materials used on that shoe and get a substantial decrease in the tariff, while at the same time producing a better shoe. So instead of so much rubber around the edge of the shoe and the toe of the shoe, they used leather instead. And so because they used so much leather instead of rubber on that shoe, I'm not talking about the sole of the shoe, the rim around it, think of Converse, they were able to reduce the tariff down to something in the neighborhood of 18%. And so that difference in the tariff really, in large part, was going to the bottom line. Let's look at some exporting law briefly. Export Trading Company Act of 1982. This relaxes antitrust law by permitting direct collaboration between firms, marketers, financiers, and banks to advance export trade. A major piece of legislation from the 1980s, a treaty called the United States Convention on International Sale of Goods, commonly referred to as CISG, Convention on International Sale of Goods. This is sales law pertaining to international sale of goods, and it's very similar to the United States Uniform Commercial Code. Right? Article 2 of the Uniform Commercial Code. And it's very similar to UCC Article 2, dealing with transfer of goods, dealing with warranties, dealing with delivery, and things of this nature. And municipal law, state law, will fill in where the CISG is involved. First time I had anything to do with the CISG was when I was at FLACT Environmental Systems Division. We had a proposed sale of air pollution control equipment for a power plant a group consortium, and the Chinese buyers wanted to use the CISG, and I had no idea what it was. I found out later. This ends the discussion of the international trade law. Again, it was simply a summary. It was not intended to be all-inclusive, but it gives you an idea of how complicated international trade can be and how complicated and entwined the World Trade Organization is and how difficult it would be to get out of it. The next lecture will be on doing business globally, looking at foreign direct investment.